Passing on your guns when you die can be a complicated mess, and you wouldn't want your kids to be in possession of illegal firearms and then get them taken away. In this video, I'm covering how to pass down your guns to the next generation without getting into any legal trouble. But first, a quick reminder, we have a gun giveaway going on. It's happening right now. You can enter for free, but it ends really soon. Just click the link in the description below to reveal which brand new gun you could win. We're all gonna die. And when you die, your assets go to the people named in your will or trust, right? Well, except if they're guns. Then maybe not. With firearms, inheritance can get complicated. Whether your wishes can be followed depends on where you live, what types of guns you own, and the individuals who would inherit those guns. The laws and procedures for transferring ownership of your firearms, whether you're alive or dead, differ upon the type of guns you have and the state where the decedent last resided. From a legal standpoint, broadly speaking, guns fall into two classifications. Some firearms, along with certain accessories, are subject to the National Firearms Act of 1934, the NFA, and then its revised version, Title II of the Gun Control Act of 1968. These include fully automatic weapons, short-barreled rifles, short-barreled shotguns, and silencers. They must have serial numbers and be registered with the Federal Bureau of Alcohol, Tobacco, and Firearms. Unregistered NFA weapons are contraband. They can't be passed down to an heir, and they can't be registered after the fact. If the executor of the estate discovers unregistered NFA firearms, he or she must contact the local ATF office to arrange for them to be abandoned. In other words, turned over to law enforcement. Firearms not covered by the NFA include revolvers, hunting rifles, shotguns, and semi-automatic pistols bought for personal or home protection. For those firearms that are not covered by the National Firearms Act, as well as the licensed NFA weapons, the best way to transfer to an heir is to go through an entity with a federal firearms license, such as a licensed gun dealer. After assisting the executor and the heir in filling out the required forms, the federal firearms license holder will hold on to the firearms while completing the background check. Upon passing the background check, the heir can collect the firearms after 10 working days, typically. You can find local FFLs by searching online at sites like fflgundealers.net and gunbroker.com. A gun trust is a way to avoid the transfer process described above. The trust is an entity you create that holds the title to your firearms. You can name multiple trustees who then share the right to possess and use the firearms covered by the trust. Since the trust stays in effect after your death, the executor of the estate isn't involved, and the firearms do not have to go through probate. Trusts are not intended to circumvent the law. However, some gun owners believe a trust might help get around any future laws prohibiting transfer or inheritance of certain weapons. While a simple revocable living trust generally ends once your assets are distributed after your death, a gun trust can be designed to last for multiple generations, and it must take federal and state gun laws into account. To create a gun trust, it's essential to work with an attorney very familiar with the laws governing the use, possession, and transfer of weapons in your state. For example, you wouldn't want to name a trustee who is prohibited by law from possessing firearms. These gun trusts are useful for people who want to share the use of their weapon with others during their lifetime. But recent ATF rules have removed some of the advantages of a gun trust for inheritance purposes. Carefully consider the advantages and disadvantages before setting up a trust. Don't fall for aggressive lawyers' sales pitches without doing your own research and getting a second opinion. So, let's say that in your will, you leave a collection of non-FFA guns to your son or daughter who lives in another state. Federal law doesn't prevent him or her from picking them up and driving them home across state lines. But your child must comply with the laws of both his or her own state or city and yours pertaining to registration and transportation of the firearms. For example, if the state that he or she resides in requires a firearms permit, your child will have to get that permit before legally possessing the guns. It couldn't hurt to research this yourself ahead of time and let your child know the rules, since there are transport procedures to follow no matter where the person is driving. Keep in mind, though, that this is good advice for any transaction involving guns. Laws are changing all the time. Do your research, stay informed, But if you have any doubt at all, consult a lawyer with knowledge of firearms laws. The last thing you want is someone you love getting pulled over for a routine traffic stop and getting booked for transporting firearms. Federal and state laws forbid certain people from possessing firearms. You can bequeath your firearms to anyone you choose, but they will not be able to take possession of the guns if they are what is called a prohibited person, and that's defined by the ATF, or if they fall into certain additional categories that may be specific in the laws of your state. Prohibited persons under federal law include unlawful users of controlled substances, people convicted of serious crimes or domestic violence misdemeanors, those judged mentally defective, or others. State laws impose additional restrictions. A record of specific felonies, violent misdemeanors, or mental conditions may disqualify people from owning guns. Some states restrict alcohol abusers from possessing firearms. Age requirements vary as well. For example, minors, people under 18, may not possess firearms in California. If you are in doubt, check with a lawyer who is familiar with your state's gun laws and the rights that you have. If you have no interest in owning any firearms passed down to you, and the guns have considerable value, you can sell them to a licensed dealer, the same type we mentioned above, to assist in transferring ownership. If you have no interest in owning any of the firearms that are being passed down to you, and the guns have considerable value, or even if they don't, you can simply sell them. Oftentimes it's best to go through a licensed dealer. Or, in the messages down below, I will leave my address. You may ship them to me. We'll figure it out. If you don't care about the money and you just want to get rid of the guns, again, ship them to me. We'll figure it out. But there are ways to legally get rid of your guns. Just make sure you follow all the federal, state, and local laws. The rules vary depending on where you live. Make sure, again, you're following all the state, local, and federal laws when you're transferring guns. If you really want to get rid of guns, I will happily accept them and give them a very good home. Thanks for watching all the way to the end of this video. Quick reminder, we have a gun giveaway going on and it ends really soon. All you have to do is click that link below and reveal which brand new gun you can win. I'm Kevin Michalowski, Director of Content for the U.S. Concealed Carry Association. If you enjoy videos like this, please subscribe to this channel and click that notification bell. We'll notify you every time something new comes out. Stay safe. We'll see you in the next video.